Welcome to the Deep Dive. We're the place where we really get into the weeds of complex stories, digging out the fascinating bits for you.
That's right. And today we're diving into a legal saga from New South Wales here in Australia. It started as a commercial dispute over land, but honestly, it spiraled into something much, much bigger.
Yeah, way more dramatic than you'd expect from a property deal. We're talking a decade-long court battle.
Absolutely. It wasn't just arguing about a contract. It touched on really fundamental stuff, contract law basics, yes, but also the really tricky areas of evidence, legal privilege.
And even how these massive high-stakes lawsuits actually get funded and run in Australia. That became a huge part of it.
It did, and we're going to zoom in a bit on one specific ruling today. You'll find it cited as 2009 NSWSC 49, or in the law reports at 75 NSWLR 380.
Why that one specifically?
Well, it's a really neat example, a key piece of this much larger puzzle. It shows how these seemingly technical rules about evidence can swing the outcome in a multi-million-dollar fight.
Okay, so our mission today, unpack this whole Barr versus Narui saga. We need to understand the people involved, the procedural twists, and there were plenty of those, and figure out why these cases still, echo in legal practice today.
Right. Let's set the scene first. The place. King's Forest. It's a big planned development area up in northern New South Wales. And within that, the specific piece of land causing all the fuss was called Cudgen Paddock.
Got it. And the players.
Yeah.
Who are the main characters in this drama?
Okay, first up, Timothy Barr. He's the plaintiff, the main guy behind his company, TBPL. Now, Barr was initially hired by the landowners, Narui Gold Coast Pity Ltd, let's just call them NGC.
Right, MGC landowners.
Yeah. He was brought in to work on the whole King's Forest development project, so he was right there on the ground, knew everything that was going on, a really key figure.
Then you've got Shigeo Narui.
Yes, Shigeo. He was a director at NGC, also linked to the Japanese parent company, Marui Norin. He was involved early on, dealt directly with Barr, and they even talked about maybe doing a joint venture for a plantation on the land.
And above him.
That would be Hiroyuki Narui. He was the president of the parent company back in Japan, Narui Norin, kind of the ultimate decision maker for NGC.
And interestingly, Barr sort of bypassed the usual channels, didn't he? Went straight to Hiroyuki with proposals.
He did, which was unusual. Hiroyuki signed some key documents, including the lease that became central to everything, and later he gave a police statement that, well, that caused a whole separate fight in court.
Okay, so Barr, Shigeo Narui, Hiroyuki Narui, three central figures.
And here's a fascinating twist, something that casts this long shadow over the trial.
What's that?
None of them testified. Timothy Barr, Shigeo Narui, Hiroyuki Narui, the people who knew the most, absent from the witness box.
Wow. Okay, we definitely need to circle back to why that happened. So the other main players are the companies themselves.
Exactly. Narui Gold Coast Plitty Ltd, or NGC, they're the defendant, the landowner, and Tim Barr Plitty Ltd, TBPL, that's Barr's company, the plaintiff and the tenant under this lease everyone was fighting about.
So how did it start? Barr was working for NGC.
Yeah, initially as a consultant on the King's Forest project, he put together a team, planning experts like a Mr. Sipple, a solicitor, Mr. Bolster, environmental guys like Mr. Sutherland, an ecologist, Mr. Warren. Standard stuff for a big development. Barr was reporting back to Shigeo Narui on how things were progressing, especially with the development application, the DA.
But then the relationship changed. It shifted from him working for them to something else.
Precisely. The idea of maybe doing a joint venture for a plantation on Cudgen Paddock seemed to fade, and instead Barr proposed that NGC should just lease the paddock directly to his company, TBPL.
And that's when he went over Shigeo's head, straight to Hiroyuki.
Seems so. And this lease, dated 23 June 2000, that's where the trouble really starts brewing.
Were there issues with the signing itself?
A couple of, let's say, historical footnotes. TBPL, Barr's company, had literally just been registered a few days before the lease date. And Hiroyuki, while he signed it, wasn't technically a director of NGC on that date, though he became one very soon after.
Did that matter in the end, his authority?
Apparently not. The court didn't seem to make a big issue of his authority to sign for NGC. The point is, the lease was signed. The deal was done, on paper at least.
Okay, so the lease exists. What were the key terms that ended up being so important?
Well, Clause 4.1 defined what the land could be used for. It just said, basically, the use to which the premises are put. A bit vague, maybe.
Okay.
Then Clause 4.3. This one was absolutely critical. It put the responsibility squarely on the tenant, TBPL, to get and keep any necessary licenses, consents, or approvals for whatever they were doing on the land.
And they had to guarantee they already had them.
Yes, it included a warranty that the required approvals were obtained and would be maintained. Big promise.
What else?
Clause 15 gave TBPL an option to actually buy the land. That's the potential jackpot for BAR. And Clause 8.1 gave NGC the right to re-enter and take back the land if TBPL breached the lease terms.
So TBPL signs the lease, gets the land. What did they start doing?
They started planting trees, specifically lemon myrtle trees, aiming to produce oil. Now, later on, there was some argument about whether the real plan was lemon-scented tea trees, but the point is, trees were planted. A plantation was established.
And the million-dollar question quickly became,
did planting this specific plantation require development consent? Did it need formal approval under the NSW planning laws, like the Environmental Planning and Assessment Act or the local Tweed Environmental Plan?
because Clause 4.3 said TBPL needed all necessary approvals.
Exactly. Was this just basic agriculture, which might not need specific approval, or was it something more involved that did? Or maybe could they rely on existing use rights? These were the technical planning law questions at the heart of it.
And NGC decided it did need approval, and TBPL didn't have it.
That was their position. On May 3rd, 2002, NGC dropped the hammer. They served TBPL with a notice terminating the lease.
On what grounds?
Breach of the lease. Specifically, they pointed to that clause 4.3, using the land without the necessary planning approval. They sometimes also referenced clause 8.1, their right to re-enter because of the breach. Essentially, they said, you broke the rules, lease is over, get off the land.
Ouch. How did BAR and TBPL react?
They didn't just pack up, they fought back. Their big counter move came almost a year later, on April 17, 2003. TBPL purported to exercise that option to purchase the land under Clause 15.
So trying to buy the land even after being told the lease was terminated.
Precisely. And that set up the core legal battle that would consume years. Was NGC's termination notice on May 3, 2002 actually valid? Had they successfully ended the lease before TBPL tried to exercise the option on April 17, 2003?
Because if the lease was already gone?
The option died with it. TBPL couldn't exercise an option under a lease that no longer existed. Everything hinged on the validity and timing of that termination.
And so began the litigation marathon.
Absolutely. Two main sets of proceedings got started. First, the lease proceedings. That's where TBPL and BAR asked the court to declare NGC's termination invalid, arguing the lease was still on foot.
And the second?
The House proceedings. That was a separate, though related, fight where BAR was trying to force the sale of a different part of the property. But the main event, the one with the landmark rulings, was really the lease proceedings.
Now, throughout this long fight, who were the lawyers involved? It must have been complex.
It was. One constant was Veriker's solicitors. They acted for the defendant, NGC, right through the whole thing. Rock solid presence.
And for the plaintiffs, BAR and TBPL.
Their team changed over the years. We don't have specifics on the very early lawyers from the sources, but by the time we get to that key 2009 evidence ruling we're focusing on, Corse Chambers Westgarth were the solicitors for TBPL and BAR.
And their barristers.
At that stage, it was Mr. R.G. McHugh, SC Senior Counsel, and Mr. J. Lazarus.
Did Corse stay on?
No, the sources indicate that later on, cores were replaced by Zavaris Legal, and then eventually by JT Law Pleadie Limited by the time the main judgment came down in 2010. The counsel teams also evolved a bit, but both sides consistently had senior counsel, reflecting just how high the stakes were.
Right. Big money, complex law, you need the big guns. But fighting these battles costs a fortune. How did TBPL afford it?
Enter the litigation funder. A company called Oscorp Group Ltd. got involved.
How did that work?
Well, TBPL gave Oscorp an option over the land and the lease itself. But more importantly, they signed a management deed, which basically gave Oscorp total control over how the litigation was run, the strategy, the decisions, everything.
So BAR's company was the plaintiff, but Oscorp was calling the shots.
Effectively, yes.
Yeah.
And NGC, the defendant, looked at this arrangement and, well, they weren't happy.
I can imagine. What did they do?
They challenged it in court. They argued this funding deal was improper, that it smacked of these old legal concepts called maintenance and champerty.
Which basically means
interfering or stirring up someone else's lawsuit, often for a share of the profits, when you don't have a legitimate interest yourself. NGC argued it was an abuse of the court's process.
How did the court first react to that?
The first judge to look at it, Justice Palmer, actually dismissed NGC's challenge. He decided Oscorp did have a genuine commercial interest in the outcome because of the option they held, so the funding was okay.
But NGC didn't leave it there.
No way. They appealed. And that appeal case, Project 28 Piety Ltd v. Barr, became absolutely landmark in Australian law.
Why was it so important?
Because this case, along with another big one called Fostiff, fundamentally changed how Australian courts look at litigation funding. It shifted the focus away from those old, slightly archaic maintenance and champerty rules.
Towards what?
Towards a more modern test. Is this specific funding arrangement actually an abuse of the court's process? And crucially, the courts recognize that third-party funding can actually be important for access to justice. It helps people or companies who have a good case but maybe can't afford the huge legal costs.
So the Court of Appeal in Project 28 said the funding could continue.
Yes, the funding itself was allowed. But, and this is critical, the court imposed a condition to prevent potential abuse.
Which was?
The funder, Oscorp, had to give an indemnity for NGC's legal costs if TBPL lost.
Ah, so Oscorp couldn't just fund the case and walk away if it failed. They'd have to pay NGC's bills.
Exactly. It meant the funder had skin in the game. It was a massive development. It gave courts a way to supervise these arrangements and protected defendants like NGC from being stuck suing a plaintiff with no money who was only able to fight because of a funder hiding in the background bearing no risk. It leveled the playing field significantly.
Okay, so the funding fight is settled. Oscorp is on the hook for costs if they lose. What happens next? Back to the main lease dispute.
Back to the main dispute, but first, they had to fight about what evidence would even be allowed at the trial. This phase was like the evidence wars, and Justice Barrett presided over a lot of these preliminary skirmishes.
Any particularly dramatic examples?
Oh, yes. One major one involved that police statement made by Hiroyuki Narui. Remember him, the president in Japan?
Yeah, the one Barr went directly to.
Right. Well, this statement he gave to police somehow ended up going on a bit of a journey. From NGC, it went to another company under strict confidentiality rules. Then the police seized it. It was used in separate criminal proceedings against Barr.
Criminal proceedings against Barr.
Yes, that was another layer to this whole saga, though separate from the civil case we're focusing on. Anyway, the statement ends up being produced under subpoena in the civil case, and the plaintiff's lawyers' corps at that time got access to it.
And NGC cried foul, claimed privilege.
You bet they did. They argued it was covered by legal professional privilege. But Justice Barrett's ruling on this was a real lesson in how not to protect your privileged documents.
What did he find?
He found NGC had effectively, or impliedly, consented to giving the statement to TBPL's lawyers.
How? By accident.
Essentially by inaction. When the documents, including the statement, were produced to the court under subpoena in the criminal case, NGC knew TBPL's lawyers in the civil case could potentially access them. But NGC didn't object strongly enough or take clear steps to prevent that access at the time.
So their failure to lock it down meant they lost privilege.
That was the finding, a very practical and probably painful lesson for NGC and their lawyers, vericers, about being vigilant when privileged material is produced, even in related proceedings.
Okay, what other evidence battles were fought?
There were challenges to expert reports. For instance, there was a report from a planning law expert. NGC objected, saying the expert was basically just telling the judge the answer to the legal question, was development approval required?
Which is the judge's job, not the expert's.
Right. The court reiterated the rule. Experts can give opinions on ultimate issues. The judge has to decide. The Evidence Act allows that, Section 80. But the opinion has to stem from their specialized knowledge. They can't just offer a bare legal conclusion. The court needs to see the expert reasoning based on their expertise.
Makes sense. What about things like documents, letters, records, hearsay issues?
Yep, that came up too. The basic rule against hearsay, you generally can't use an out-of-court statement to prove that statement is true.
Right. Section 59 of the Evidence Act.
But there are exceptions. One big one is the business records exception, Section 69. If a document is part of a business's regular records made by someone with knowledge, you can often use it to prove what it says.
Things like Barr's regular reports back to Narui.
Those got in under Section 69. They were seen as standard business communications. But then there were these things called the trip journals, allegedly kept by Shigeo Narui.
NGC wanted to use those.
Yes, but the court rejected them. Why? Firstly, there were real doubts about their authenticity. Where did the originals come from? Could they prove they were genuine business records?
And secondly,
even if they were genuine records, there's a part of the business records exception, section 69, subsection 3, that says it doesn't apply if the record was likely made specifically for or anticipating legal proceedings. The court thought that might be the case with the journals.
did the plaintiffs try any other way to get the journals in? Maybe arguing it was just easier to let them in.
They did. They pointed to a general discretion judges have under the Civil Procedure Act, Section 70, to dispense with evidence rules to save time and cost, especially if the facts aren't seriously in dispute. They argued NGC wasn't really disputing who wrote the journals.
But the judge didn't buy in.
No. Justice Barrett said there was a genuine dispute about the provenance, especially concerning the Japanese originals versus translations. He wasn't going to use that general discretion when the fundamental reliability of potentially key evidence was questionable.
Okay, so lots of fights about evidence, which brings us back to that specific ruling you flagged. 2009 NSWSC 49, the Sharp Valuation Report. What was the deal there?
Right. This is a great example of evidence law in action. So the plaintiffs, TBPL and BAR, represented then by Coors with McHugh SC and Lazarus, wanted to use a valuation report for the land, prepared by a firm called Sharp & Co.
Okay, a standard expert report about how much the land was worth.
Sort of, but it wasn't prepared for the litigation initially. And NGC, represented by Veracruz with Mr. Einfeld QC and Mr. Harding, objected strongly.
On what basis?
Several grounds. First, procedural ones under the court rules, the UCPR. They said the report didn't have the proper acknowledgement signed by the expert saying they understood their duty to the court that's usually required under Schedule 7 of the rules. Plus, they argued it was served too late, messing up the court's timetable.
And substantive objections.
Yes. The big one was the opinion rule, Section 76 of the Evidence Act. NGC argued that if the plaintiffs wanted to use the report to prove the actual value of the land, that was inadmissible opinion evidence. It's just Sharp's opinion, not a fact.
Okay, seems like strong objections. How did the plaintiffs respond? That sounds like Mr. McHugh SE and Mr. Lazarus had a tricky job.
They came back with a really clever argument. They essentially said, okay, fine, maybe we can't use it directly to prove the land's actual value right now because of the opinion rule and maybe those procedural issues, but the report is relevant for a different reason.
Which was?
To prove Timothy Barr's state of mind at the time he commissioned and received the report. They argued it showed what he believed the land was worth, how he was approaching the deal, the option, everything. His state of mind, they argued, was relevant to other aspects of his case.
Ah, so not using the report to say the land is worth X, but Barr thought the land was worth X based on this report.
Exactly, and Justice Barrett accepted that argument. He found the report was relevant for that alternative purpose, proving Barr's state of mind. And there is an exception to the opinion rule for evidence relevant for a non-opinion purpose. That's Section 77 of the Evidence Act.
So the report gets its foot in the door via Section 77 for the limited purpose of showing Barr's state of mind.
Correct. But here's where it gets really interesting. Because of Section 60 of the Evidence Act.
What does Section 60 do?
Section 60 is powerful. It basically says that once evidence is admitted for any legitimate purpose, like proving Barr's state of mind under the Section 77 exception, it can then generally be used for all purposes relevant to the case.
Wait, so even though it got in the door for the state of mind reason, Section 60 might mean it could also be used to prove the actual land value.
Potentially, yes, unless another evidence rule blocks it, or the judge uses their discretion to limit its use. Section 60 can effectively bypass the original objection, like the opinion rule in this case, once the evidence is admitted for another valid reason.
That seems almost like a loophole.
It's a deliberate feature of the Evidence Act, designed partly for efficiency, but courts are very aware of the potential prejudice it can cause, which is exactly what Justice Barrett considered next.
He was worried about NGC being unfairly disadvantaged.
Yes. He was concerned about the lack of quality control, that missing expert code acknowledgement, and the fact that the expert from Sharp wasn't available to be cross-examined on the valuation. Using the report to prove the actual value without NGC being able to test it properly could be unfairly prejudicial. That's where Section 136 of the Evidence Act comes in.
Section 136 lets the judge limit evidence.
Exactly. Section 136 gives the judge discretion to limit the purpose for which evidence can be used, or even exclude it altogether if its probative value, how useful it is outweighed by the danger of unfair prejudice or misleading the court or wasting time.
So what did Justice Barrett do with the Sharp report using Section 136?
He took a pragmatic approach. He acknowledged it was in it for the state of mind purpose via Section 77. He acknowledged Section 60 could potentially make it usable for proving value. But because of the concerns about prejudice, the procedural flaws, no cross-examination, he used his Section 136 discretion to initially limit its use. Meaning, for the time being, it could only be used for the non-opinion purpose of proving Barr's state of mind, not for proving the actual land value. He balanced the relevance against the fairness concerns.
So what's the takeaway from this 2009 NSWSC 49 ruling? What's the practical guidance?
It's really valuable. It shows that expert reports, especially ones created before litigation kicks off and maybe don't tick all the procedural boxes, aren't automatically out. You might be able to get them admitted for an alternative purpose using exceptions like Section 77.
And then Section 60 potentially broadens their use.
But judges can and will use their discretion under Section 136 to carefully manage any unfairness that might arise, especially from procedural noncompliance or lack of cross-examination. It shows the rules aren't always absolute barriers. There's flexibility and judicial management involved in getting relevant evidence before the court fairly.
A very neat illustration of evidence law in practice. Okay, so the evidence wars are fought, the trial finally proceeds, and we come back to that point you made earlier, the absent stars of the show.
Yes, the shadows in the courtroom. Timothy Barr, Shigeo Narui, Hiroyuki Narui, the three key players, none of them giving evidence.
How does the court deal with that when someone you expect to hear from just isn't there?
It applies a principle from a famous case called Jones v. Dunkel.
The Jones v. Dunkel inference. What does that allow the court to do?
It allows the court to infer when a party doesn't call a witness they logically would be expected to call if their evidence would help, that the witness's evidence would not have assisted that party's case.
So it's not quite assuming they'd say something bad, but assuming they wouldn't have said anything good.
That's a good way to put it. It allows the court to more comfortably draw conclusions on the evidence that was presented, knowing that a potentially helpful witness wasn't called by the party they might have helped.
Why didn't Barr testify? What was his reason?
His lawyers told the court it was because he feared reactivating those dormant criminal charges we mentioned earlier. He was worried about self-incrimination.
Did the judge accept that?
Justice Barrett said the fear was understandable, yes. But he ultimately decided it wasn't a sufficient reason to stop the court from drawing adverse Jones v. Dunkel inferences against TBPL's case on all the things Barr could have shed light on.
Even though testifying might have exposed him legally.
Well, the court noted there are protections, like Section 128 certificates under the Evidence Act, which can prevent evidence given in a civil case being directly used against you in a later criminal case.
But that's not absolute protection.
No. It doesn't necessarily stop authorities using the fact you testified or things learned from your testimony to maybe find other evidence or pursue new lines of investigation. It's a calculated risk for any witness in that position. So, Barr's understandable fear wasn't enough to shield his company, TBPL, from the negative inferences.
And were inferences also drawn against NGC for not calling the Naruis?
Absolutely. The court applied the same Jones v. Dunkel principle to NGC for their failure to call Shigeo and Hiroyuki Narui. Given their central roles in the lease, the termination decision, everything the court expected to hear from them, and their absence allowed inferences to be drawn against NGC's case too.
So after all the procedural fights, the evidence battles, the absent witnesses, we finally get to the main judgment.
Yes, the culmination. Justice Barrett delivered his main judgment in 2010. By this point, remember, the plaintiff's solicitors were JT Law Pilati Limited, while Verrickers were still there for NGC.
And the outcome. Did NGC validly terminate the lease?
Yes, that was the central finding. Justice Barrett held that NGC had validly terminated the lease back on May 3rd, 2002. Why? Because TBPL had breached that critical clause 4.3. They had used the land for the plantation without getting the necessary planning approvals, which the court found were required. And importantly, the judge found this breach was fundamental and couldn't be remedied after the fact.
And the consequence for Barr's big hope, the option to purchase.
Fatal. Because the lease was already validly terminated in May 2002, TBPL's attempt to exercise the option in April 2003 was completely ineffective. It was too late. The option was dead.
So a major loss for TDPL and Barr on the main claim. Did they lose on everything else too?
Pretty much all the main lease claims. The court rejected their arguments for rectification, trying to rewrite the lease, finding there was no shared mistake or intention to fix. It rejected their estoppel arguments, partly because the lease had an entire agreement clause saying the written contract was the whole deal.
Any breach of good faith by NGC?
The court found no breach of any implied duties of good faith or cooperation by NGC, and it refused to grant TBPL relief against forfeiture that equitable discretion courts have to sometimes save a lease despite a breach. The judge felt the nature of the breach, using land without approval, didn't warrant that relief.
Sounds like a comprehensive win for NGC. But you mentioned a twist earlier.
Yes, it wasn't quite a total wipeout for the plaintiffs. In a later judgment dealing with consequential matters, Justice Barrett found TBPL was actually entitled to some money back from NGC.
How? If they lost the lease case?
It was based on restitution or unjust enrichment. The court found that after the lease was terminated, TBPL continued working on the plantation for a while, and even though the lease was gone, that work provided a benefit to NGC.
Benefit.
By continuing the plantation work, TBPL helped keep down native regrowth on Cudgen Paddock. This was actually helpful for NGC's broader development plans for King's Forest. Because NGC got this benefit from TBPL's post-termination expenditure, they had to pay TBPL back for that specific work.
How much was it?
It was later calculated at just over $331,000 plus interest. So while they lost the lease and the option, they did claw back some of their expenses based on this restitution principle. It really shows you the complex, sometimes mixed results you can get in these huge cases.
Absolutely. So looking back at the whole decade-long saga, what's the legacy? How has Bar v. Narui impacted legal practice in Australia?
Its impact has been pretty significant, indelible, as some sources put it. The biggest, most profound impact is definitely in litigation funding.
Through that Project 28 v. Bar appeal.
Exactly. That case fundamentally shaped the modern approach. It moved away from just saying funding bad based on old rules to asking, is this specific arrangement an abusive process? And crucially, it established that mechanism of requiring the funder to provide an indemnity for the other side's costs. That balanced access to justice with controlling potential abuses, and it's the framework we still largely operate under today.
And in evidence law.
The rulings, especially the 2009 one on the Sharp report, gave really practical guidance. They showed how you might get pre-litigation reports admitted using Evidence Act exceptions like Section 77, how Section 60 can broaden their use, but also how judges use Section 136 discretion to manage fairness and prejudice when procedural rules aren't perfectly met. Useful lessons there.
Anything else?
Well, the whole case is a demonstration of effective, though complex, judicial case management, handling intricate evidence, procedure, funding, all over a very long time. And the Jones v. Dunkel aspect really hammered home the strategic importance and potential negative consequences when key witnesses don't front up to the witness box.
What happened right at the very end, after the main judgment and the restitution ruling?
The inevitable fight over costs. Who pays whose legal bills? There were more judgments dealing with this. NGC, having won the main game, largely got their costs, but they tried to get a gross sum costs order, basically asking the judge to just estimate and award a lump sum instead of going through detailed assessment, arguing it would be quicker given Bar and TBPL likely couldn't pay anyway.
Did that work?
No, the court stuck to the usual process. It also declined to split up the costs based on specific issues NGC might have lost on, like that restitution point. The final step involved sorting out all the cross-claims for money and costs, setting them off against each other to figure out who owed what in the end.
So it started with a land deal, a plantation.
And morphed into this huge legal battle that ran for years, generated landmark rulings on funding and evidence, and really changed parts of the legal landscape here in Australia.
It's a powerful reminder, isn't it? How complex these big commercial disputes are, and how those seemingly dry technical rules about evidence or procedure or funding can completely dictate the outcome and even reshape the law itself.
Absolutely. And understanding cases like this, it matters because it gives you a window into how the courts actually work, how they manage enormous amounts of information, balance fairness with finding the truth, and adapt to new challenges like litigation funding.
And it does leave you pondering that final point, doesn't it? In a courtroom drama where the main characters, the people who knew the most, Bar and the Naruis, chose silence, can we ever feel like the whole truth really came out? Even with legal principles like Jones v. Dunkel filling some gaps, does justice feel truly complete without hearing directly from those at the very center of it all?
That's the lingering question, isn't it? Something to think about.